Then we refer to whatever the claim is that the creditor has as an unliquidated claim. So what that judgment does is it liquidates the claim. It comes up with a sum certain. Now, why is that important? Well, I could sue you, but I'm not guaranteed that I'm going to win. After all, if I sue you and let's say it's before a judge or a jury and the trier of fact says, you haven't proven your case, well then I've lost and I've got nothing against you. So that's an unliquidated claim. Now that means that there's no judgment that can be used to record a lien. If I sue you and that case is pending and there is no judgment yet, you file a bankruptcy, well, it is going to depend on what chapter we're in as to what direction we go, but that's still an unliquidated debt. This does open up a fairly lengthy discussion. So what I'm going to do for our purposes here is just kind of look down from 30,000 feet, as it were. Let's say Chapter 7, what happens there? In Chapter 7, if I've got this pending lawsuit against you and you file that Chapter 7 bankruptcy petition, the filing of the petition triggers something called the automatic stay, which stays the lawsuit that I have pending against you. So if I want to continue that lawsuit, I have to go to the bankruptcy court and ask the bankruptcy judge to lift the stay so that I can return to the California Superior Court and continue prosecuting my lawsuit. There's a wrinkle. If I'm successful, but the debt is of the dischargeable variety, then I will have wasted my time, effort, and money in the California Superior Court because I can get that judgment, but if the debt has been discharged, then I've got nothing other than a piece of paper that may be nice for framing and hanging on the wall. If I try to take that judgment, record a lien against the property, well, then I'm in violation of the stay because I'm seeking to collect against my judgment, which was discharged in the bankruptcy. One way around it is if I think that the debt you owe to me should be determined to be non-dischargeable, let's say I think it was incurred, for example, through fraud, then in addition to having the stay lifted so that I can go to the California Superior Court and continue my action, I must, in a timely fashion, file an adversary proceeding, a special kind of a lawsuit in the bankruptcy court to get a determination of non-dischargeability. If I'm successful on that, then whatever judgment I get is a valid debt that survives the bankruptcy case, and then I can record a lien against the property. If it's a Chapter 13, well, I may still wish to do this so that I can have a liquidated amount because the amount that I get paid through the plan is dependent upon the sum certain of my claim. So I may still file that motion for relief from the automatic stay, and maybe I'll also do the adversary proceeding to get a determination of non-dischargeability, and I'll file a proof of claim in the Chapter 13 so that I can get paid through the Chapter 13 plan. Finally, in the Chapter 11, it's similar to the Chapter 13. I do the same sort of thing, get the motion for relief from stay granted, do the non-dischargeability action if the debtor is not a business, and also file a proof of claim so that I can get paid through the Chapter 11 plan. In sum, though, if there is no judgment, then there is no lien.